it didn't do that. This is exactly what I did. Same thing. It's me.
Yeah.
Just send me that email.
This is our message.
What's the live stream on?
Right there.
Mhm.
Right there.
All right, so this is where I scroll on to
Right.
find and then.
Mhm.
All right. I kind of knew what to do, but that threw me off.
Mhm.
Not this one.
Mhm. Hold on a second. Edit video.
Oh. Let me go over there. That's fine.
It's right here.
But that's when I go to that. And then I go down.
Mhm.
All right.
Show more. Right there. It's all right here, honey.
I know, but now I'm
Go ahead.
nervous because I was trying to do it in advance.
Let's see what early. There it's on. It's ticked. It's right there. Go up.
Just so you're aware, you're not muted.
Yeah, we haven't quite started.
Well, I just don't want you to say anything horrible about me. Well,
About Alan? Alan's a
No.
nice guy. We love him.
All right.
Where's the season?
Right here. Maybe put on there. But I think it's fine. I can't. Keep doing that. It's right there. I saw it earlier. Right there. Okay.
Thank you.
All right. So you should be all good now.
Thank you so much. Okay, so now I have to copy this, right?
Yeah, copy.
This is the file.
Copy and paste that. Copy your email. Right, you don't have to send it and send it in the next comment.
Okay.
Yes, good morning, Council.
Good morning, my lady.
So Richards, is it just us again?
It does seem to be.
What's happening? This is a matter of Fiona Miller and Damon Edwards,
Yes, my lady.
2022. And I see I have proof of service, an affidavit of service. But there's a hearing in chambers. That for today's hearing.
Was that hearing
This was
on
26th
the?
of May.
Yes,
That's not for today. On the 26th of May, then, I see the respondent appeared. Did he appear in person? Respondent's address.
I believe he was there in person.
Yes, because he gave me his email address. And I
Yes.
said that the hearing would be today, Wednesday, the 9th of November at 11 a.m. by Zoom.
Yes, and I believe that I did see. I'm just reopening my emails, but I believe I did see his name was on the Zoom invite, and I'm just going to check.
Okay, well, let's double check that.
So it was actually forwarded to me. So I don't see the address, but I do see his name
It should
on
be-
Miss Butterfield's email. It was sent at 12:46 on Friday, the 4th of November. And the recipients seem to have been herself, Miss Binns, Mr. Rogers, Mr. Edwards, the Supreme Court, and
Are you able to open, are you looking at a hard copy or are you looking at it on screen?
I'm looking at it on screen.
Can you open up that email address and tell me for Mr. Edwards what it reads?
Unfortunately, I can't because I wasn't actually included in Miss Butterfield's original email. I just got it.
All right, well, that's all right, Miss Butterfield or Miss Williams Grant, do you? Miss Williams Grant? Okay, I hear footsteps coming my direction. I don't know if someone's gonna come to my office.
I'm here, yes.
Oh, good, thank you. Ms. Williams Grant, I just wanted to find out if Mr. Damon Edwards was included in the email service disclosing the Zoom details for this hearing. Can you make that inquiry for me?
Yes, I
please?
will.
I'm gonna stand the matter down for 5 minutes and liaise directly with Ms. Williams Grant, and we'll come back. What time is it? No, 11:08 on my screen. Let's come back at 11:15 and.
Very
see
well, my lady.
where we are
Thank
on
you.
this. Okay, thank you. All right, we're back a few minutes early, but we do have some result. Please, can you confirm for the record, Ms. Williams Grant, the service on Mr. Edwards?
Yes, the Zoom details were sent to Mr. Edwards on the 4th of November at 12:46.
Thank you very much. So I'm quite satisfied that he had notice of this hearing and he has not appeared and he's not communicated to the court the reasons for his absence. It would seem to me that we could proceed, but I will hear from you, Mr. Richards, as to what
Yes, my lady, I agree.
thoughts are. Yes.
So, my lady, I haven't filed any written submissions in this matter because none were directed, and I didn't want to be seen to be taking advantage of Mr. Edwards' lack of representation, as I understand it.
That's fine, but you can take the file as read. I have read through the. I think this is the one. Correct me if I'm wrong. Sorry, let me just make sure that I'm. Where there was, is this the decision against acting magistrate Ms. Orly Cassidy?
Yes.
And she dismissed for want of prosecution after the close of the Crown's case. The matter instead of having decided it.
Yes.
The evidence that was already heard.
That's right.
Okay.
So the trial actually commenced before Her Worship on the 17th of November of 2021.
Mm-hmm.
It then continued on a subsequent occasion, which was the 10th of December 2021.
Mhm.
By the end of that session, all of the Crown's evidence, which was some 3 police witnesses who gave oral evidence, an agreed statement, and some body cam footage had been received by the court. And indeed, the respondent himself had given evidence as well.
Right.
It was adjourned to the 21st of December 2021 in the expectation that a defense witness would be called. It's not apparent to me exactly who that was, but the defendant had given the court to understand that he expected to call a defense witness, and that would have been the only evidence left to present in the trial. But on the 21st of December 2021, the acting magistrate was not actually sitting. I don't know exactly why, but I believe it may
I
have
think
had
there was some confusion about whether or not she'd been properly, that her appointment had been properly gazetted, or
Yes,
if she had jurisdiction. I saw something in the record to that.
yeah, I think that's right, my lady, yes. I'm not sure myself whether that actually matters in the case of a matter that's already part heard before the relevant
It
judicial
usually does
officer.
not, but okay.
But there it is. She wasn't there, and so the matter was adjourned again to the 11th of January of this year, when it was listed not in one of the regular criminal courtrooms, but in Hamilton Magistrates Courtroom number 3, which is normally, and I believe on this occasion would also have been generally, a civil court. So this matter wasn't reached until, according to the record, and this is page 69 of the record of appeal, which is the penultimate page, I believe, in the bundle.
Yes.
The matter was called on at 10:13:12 a.m. And I pause to note here, as perhaps your ladyship has already appreciated from an examination of the record, that we don't have the acting magistrate's notes. What we have is a transcript that the court has done of Courtsmark, because it seems the acting magistrate's notes have been lost. And my authority for that proposition is the highlighted endorsement at the bottom of the index to the notice of appeal. Has your ladyship noted that?
I will in a moment. Let's see. What's my recordings for? That's something else. Yes, I see it. Yes.
So all we have is the transcript of the Courtsmark, but it's apparent from that, as I say, the matter was called on at about 13 minutes past 10. And there's then a very short exchange between the acting magistrate and Mr. Edwards. Pleasantries are exchanged. The magistrate observes she does not have a Crown Counsel. Defendant complains that this is going on 3 years.
Mhm.
Ms. Cassidy says, I'm not impressed. The defendant says, it's been going on 3 years, Your Worship. And Ms. Cassidy then refreshes her memory from her last note, which confirms that it was Mr. Edwards' witness, his brother, who was, no, sorry, not his brother. She's talking about her brother magistrate,
Yes.
who was
Mhm.
expected to give evidence in what was left of the trial. There's something inaudible from the defendant. Miss Cassidy continues, it was adjourned to today for continuation and I am ready to continue. Defendant says, and so am I. I have to get back to work,
Mhm.
show of teachers. So it's not entirely clear at that point whether his witness was actually in attendance, but he seems to have been ready to proceed in any event. And then Miss Cassidy simply says, okay, so I'm going to record the time at 10:14 a.m. So this exchange appears to have lasted less than a minute, which is hardly surprising looking at its length. Crown fails to appear and no explanation for absence. Crown's case is dismissed. Have a good day. And then a couple more pleasantries conclude the exchange.
Mhm.
So in my respectful submission, there was apparently on the record a failure by the court to appreciate what its powers were in these circumstances, and they are set out in the Criminal Jurisdiction and Procedure Act. Now, does your ladyship have a copy of that available, or should I try to share my
No,
screen?
it's fine. I have a tablet close by. 1 minute. Here it is. Yes.
So if your
That's what I'm
ladyship
looking at.
looks, please, at section 10
Mhm.
of the CJPA,
Yes.
which is headed non-attendance of prosecutor,
Yes.
that provides that where at the time and place
Sorry,
appointed.
1
for the-
moment. I can see that the court associate's here, so I don't know. Okay, I'm just being told that Mr. Edwards is trying to join. I think you can continue, Mr. Richards.
Okay. So subsection 1 of section 10,
Yes, okay, I hear you now. Mhm. So
subsection,
section 10, non-appearance of prosecutor.
yes. So where at the time and place appointed for the trial or adjourned trial of an information, the accused person appears or is brought before the magistrate's court and the prosecutor does not appear, the magistrate's court may dismiss the information, or if evidence has been received on a previous occasion, proceed in the absence of the prosecutor.
Mhm.
Subsection 2 provides where instead of dismissing the information or proceeding in the absence of the prosecutor, the magistrate's court adjourns the trial. It shall not remand the accused person in custody unless he has been brought from custody or cannot be remanded on bail by reason of his failure to find sureties. So subsection 2, in my respectful submission, recognizes that in addition to the options provided for in subsection 1, the court retains its general discretion to adjourn the proceedings. And that, of course, is provided for in section 7 of the Act. So if your ladyship turns back briefly to section 7.
Okay, 1 moment. Yes.
You'll see that subsection 1 of section 7 provides a general power to adjourn. Magistrates' court may at any time on its own motion or on the application of a party to proceedings, whether before or after beginning to try an information, adjourn the trial.
I mean, is it your position that she exercised her discretion wrongly in refusing to adjourn?
No.
Or is it more so your primary position that having exercised her discretion against an adjournment, she was wrong to have dismissed it and
Yes.
ought to?
That it's the latter point. What I'm trying to do is set out all of the options that she
I
had
see.
before her.
Okay.
Respectfully, what we do know of the acting magistrate's thinking as it's reflected in that very short exchange with Mr. Edwards suggests that she hadn't really even directed her mind to what her options were. She just simply summarily dismissed the matter, which
Right.
in the particular circumstances of this case, I would respectfully suggest was an abuse of her discretion. I've already explained that in this case, not only had evidence been received, but in fact, the Crown's case had completed there was no suggestion that the evidence at the close of the Crown's case was insufficient. The defendant himself had testified, and the only remaining evidence, if in fact the defendant ultimately had sought to present it, would have been that of his witness. So my first observation, as I say, well, sorry, I haven't made this point yet, sorry. The first observation I would make respectfully is a practical one, that there is no evidence of any effort respectfully being made on the face of this record to inquire into the reasons for the absence of Crown Counsel from the courtroom. Happily, instances of the unexpected absence of Crown Counsel are rare, but I have to acknowledge that they're not unheard of. And generally, in my submission, the court will normally cause a call to be made to the office of the Department of Public Prosecutions seeking the urgent attendance of a prosecutor. Alternatively, sometimes an inquiry is made with the assistance of court staff of a prosecutor who is appearing in one of the other courtrooms that generally transact criminal business. And in this instance, of course, that would have been Court 1 or Court 2. Had such an inquiry been made on this occasion, the learned acting magistrate would have been advised that Crown Counsel who had commenced the trial, Ms. Simmons, was out sick. And I would anticipate that an alternative prosecutor would have been dispatched very urgently to come before Acting Magistrate Cassidy to make either an appropriate application or indeed perhaps to simply continue the matter, depending obviously on the outcome of any other application that may have been made. Now, I do accept respectfully, my lady, that the prosecution should already have apprehended that there would, in the absence of Miss Simmons, have been the need for another prosecutor to attend. But in my respectful submission, in all the circumstances, it would still have been reasonable for the court to have made at least some effort to inquire of the department why it was that nobody was present. And as I say, in general terms, when these instances do unfortunately arise, that's exactly what is done. Indeed, had that inquiry been made shortly after the court sat, which is apparent it did at 9:30, and when it must have been engaged with other likely civil matters that it was also due to hear that day, but may well have observed that no prosecutor was present, it is probable, in my respectful submission, that one would have been in attendance by the time that this matter was actually called on at 10:15. Now, I think I see that Mr. Edwards, or somebody at any rate, Galaxy,
I assume it's Mr.
may have
Edwards.
just joined the meeting.
Mr. Edwards, would you please activate your video so I can see your face? Okay.
Good morning. I'm sorry I'm late. I just received the Zoom link. My apologies. Actually at a tournament. I apologize.
Okay. We've obviously started the hearing, so I want to continue. The prosecutor is taking me through his submissions as to why the magistrate erred in dismissing the matter. In doing so, he's referred me to Section 7 and Section 10 of the Criminal Jurisdiction and Procedure Act, which effectively says that a magistrate has a discretion to adjourn where a prosecutor, in circumstances where a prosecutor has not appeared, or more specifically under Section 10, which deals with the non-appearance of a prosecutor, the magistrate's discretion to dismiss the information or to proceed in the absence of the prosecutor. So that's basically where we are. I want to continue without any further disruption, and then you can obviously respond. Mr. Richards, I'm looking at Section 10(1).
Yes.
And the question which comes to my mind is whether the magistrate does in fact have a discretion to dismiss where evidence has been received. The way that Section 10(1) reads, it's arguable that the discretion to dismiss is in circumstances where no evidence has been received, but where evidence has been received, the discretion is then to well, I suppose if it's a discretion to proceed in the absence of the prosecutor, the alternative must be to dismiss.
Or adjourn.
Or
There is
adjourn.
always the option to adjourn because that's a generally available option in my respective
Right.
submission under section 7.
So then
So-
that, so then my question therefore is there any sort of discretion conferred by this provision for the magistrate to dismiss where evidence has already been received?
Right. So my position respectfully on that, my lady, is that there is not by this section a discretion to dismiss in circumstances, or sorry, let me be more precise. There is not a discretion to dismiss for want of prosecution in circumstances where evidence has been called.
Okay,
In those circumstances, there would be nothing to prevent the court, if it decided, as it's entitled to under subsection 1, to proceed in the absence of the prosecutor, from then saying, well, the evidence that I have heard is insufficient. And for that reason, not for want of prosecution, but for insufficiency, the matter is dismissed.
Mm.
And if one imagines a hypothetical where only one out of several prosecution witnesses had given evidence, and clearly that evidence alone was not sufficient to support the charge, if the court decided, and we don't know what the other circumstances may be, but if the court properly decided that in the particular circumstances of that hypothetical case, that it should proceed in the absence of the prosecutor rather than adjourning,
Mhm.
then I would accept that it would have the power to dismiss the matter for lack of sufficiency,
Mhm.
but I would not accept that it has the power to dismiss for want of prosecution.
right.
And I have to say that I have looked for cases that confirm that view, and the only cases that I have found on the English equivalent of section 10.1, which is section 15.1 of the Magistrates Courts Act 1980, are concerned with circumstances where no evidence had been called. So they seem to deal with situations where the matter was listed for trial, no prosecutor or attended, and or was available to commence the trial, and the magistrates dismissed the matter for want of prosecution before any evidence had been called. And undoubtedly they have that discretion under subsection 1, albeit that some of the cases have resulted in conclusions that they exercise that discretion wrongly. What I have not managed to find, what I think is novel in this case, is a situation where the evidence has started. And I do recognize that had she decided between the option of proceeding in the prosecutor's absence or adjourning, and decided that she should proceed in our absence, the learned acting magistrate would have been entitled to go on and evaluate the evidence and may have come to the conclusion that it was insufficient. That would be a proper basis upon which to have dismissed the information.
Right. All
But
right.
that's not what she did.
No, I understand. Let me ask you some questions in terms of the chronology. I just want to understand how much time has lapsed, because I see that there's a complaint about 3 years and so forth. When did this trial start?
So the trial actually started before her worship on the 17th of November 2021, my lady.
Okay. And when did the Crown's case close?
The trial then adjourned and resumed before her on the 10th of December 2021. And on that occasion, the Crown closed its case and the defendant gave his evidence as well.
Okay.
It was then adjourned to the 21st of December 2021, which is the day when the acting magistrate wasn't sitting.
Right.
So it was further adjourned to the day on which it was dismissed, which was the 11th of January 2022.
Okay. So we're looking at the 17th. So the two sitting days were the 17th of November, the 10th of December in terms of evidence.
Yes.
Okay. And what is the relief that you are seeking for this to be remitted to the same acting magistrate to reconsider the evidence? What are you asking for?
Well, my lady, I think you have two options, bearing in mind, obviously, that the trial had substantially completed. you could remit the matter on the basis that the acting magistrate is to continue and to conclude the trial. There is a practical difficulty, which is, as I say, that the prosecutor who had conduct of the matter before her is no longer employed in my office. So it will not be possible to resume the matter exactly as it was at the point that it was dismissed. I'm also cognizant of the fact that acting magistrates are somewhat scarcer these days, since there's a full crop of full-time magistrates, than they have been for a while, because there have been vacancies in the summary bench which have now all been filled. So I have to confess that I suspect the matter may actually be tried more expeditiously if it is simply remitted to be tried before a new magistrate, than if we have to try and figure out when acting magistrate custody is available, because certainly it's within my experience, consistent with what happened in this case, I think to some extent, that it can be difficult hearing anything more than a very short matter before an acting magistrate. If you have to adjourn part heard, it's quite often the case that for whatever reason, subsequent dates don't work out, and either the magistrate's not present or other reasons hold things up. So this is the kind of case that I would have thought would probably be tried in a single session before a full-time magistrate quite often. It's not a particularly complex matter. I suspect that in fact that may be the more efficient way of disposing of it.
But I would also take into consideration that we're looking at an offense in respect of November 2019.
Yes,
We're now approaching 2023.
yes.
My concern is for the fairness in sending this back to the magistrate's court for retrial, which will not likely happen, it would seem to me, until 2023.
I think your ladyship's right. It won't. No.
And I have to say that gives me some pause.
I can understand that, my lady, and of course I recognize that had the matter concluded in January of this year, and even supposing for the sake of argument that Mr. Edwards had been convicted, he would probably be getting towards the end of his period of disqualification by now. So whilst I don't formally concede that the matter should not be remitted, I am, as I seem often to be when I'm before your ladyship, more interested respectfully in the principle than the actual outcome.
Yes.
May I say
I will call on you, Mr. Edwards. Just one moment, please. It seems to me that this may very well be an appropriate case to focus more on the principle, as opposed to what would otherwise be the relief.
Yes. Well, it doesn't entirely, if I may say so, surprise me to hear that that is your ladyship's provisional view. And as I say, I'm not formally conceding that it shouldn't be remitted, but I do recognize that there are arguments to support that that stance, certainly. I don't know whether your ladyship actually wants to hear further from me.
I don't think I need to. I was going to then call on Mr. Edwards to see if he wanted to make some remarks, statements, or just address me generally.
Yes, of course.
Okay. Yes, Mr. Edwards. Before you start, because you're not represented by counsel, I just want to make sure that you understand the exchange between the prosecutor and myself just now. Okay.
Yes, I did.
You understood everything?
For the minimal part that I heard, yes, I did understand.
All right. So the last part of it is obviously I expressed a concern because of how much time has passed, whether it would be fair in the circumstances to actually remit this for trial. If I agree with the prosecutor that the magistrate erred in summarily dismissing your case as opposed to proceeding in the absence of the prosecutor and deciding the evidence as it had already been heard. All right.
Yes.
And to that end, that's why the prosecutor referred me to section 10. You probably don't have it open before you, but section 10 of the Criminal Jurisdiction and Procedure Act basically gives the magistrate a discretion to either dismiss an information, and it would seem that in dismissing the information, that would be in circumstances where no evidence has been heard,
Yes.
or where evidence has been received, to either proceed in the absence of the prosecutor or to adjourn the matter. Instead, what she did was to just summarily dismiss it, and that's the prosecutor's complaint, that as a matter of law, she was wrong to have done that.
Okay, I understand that part. We never got to our final summation. I think it's called a summation, or we never got to our finals.
The trial did
And
not conclude. She dismissed it before the defense would have been able to have completed its own case. So the prosecutor is suggesting that either the case is remitted to the magistrate's court, to the same acting magistrate, and he's acknowledged the impracticalities of that, or it's remitted for a retrial to start afresh, anticipating that that could be dealt with in one session. And as I've already explained to you, as I started in my explanation, I'm concerned so far, I have to say, I'm concerned for the amount of time that has passed. So that's obviously something that you would want to highlight, I would think.
yes, I really would, because like I said, this has just been put off and put. I mean, it's no fault that COVID came and whatnot, but it's just been so long. And even during the trial and how the trial actually went, it wasn't cut and dry or straightforward. It was a lot of it was a lot of I don't want to say they're trying to railroad, but it was a lot of inconsistencies in the trial. That's why it went so far. I mean, so long, and not just a cut and dry case. So, if you can remember when I spoke to you the very first time, I was, I wasn't joking or whatever, but I was saying, oh, is Cassidy Miss Cassidy, or is she going to be back on the case or whatever? Because it was a lot of I don't even know what the word to say, but it wasn't just a straightforward case, milady. It wasn't a straightforward case, and for this to come back up again, after I've already spoken to the officers apologized to me for what happened, and for this to come up again, it's just, I don't know what to say. I really don't know what to say.
Okay, but I understand you, Mr. Edwards. What I hear you saying essentially is that you feel that it's been a long road and you don't want it to be further prolonged by the matter being remitted.
Of course I wouldn't, because I actually took a grievance out on the police after this, and then I dropped it because of the fact that the police officers had gotten back to me and apologized to me on behalf. So I actually forgot about it after it was dismissed and left it alone. Now, if it comes back up again, that's going to make me want to just bring up my grievance again.
Well, that has nothing to do with this court, not to be any less interested.
That's the case, and I understand that, and I understand what the prosecution is saying, but yes, it's just been a long time. That's all I can say.
All right. All right. It is Mr. Richards. I don't suspect you have anything you want to say in response. Okay, it's standard for this court to deliver its decisions in writing, and so I will do so for this. I don't anticipate it will take very long. The normal procedures that you receive a copy of that written decision via the registrar through the registry office, and I will then pronounce the formal decision on the court record without the requirement for the parties to attend. so that it is still delivered in open court, okay? I propose to do the same for this hearing, so you can expect to hear from someone from the Supreme Court with a copy of my written decision. Okay, and I think that should come out in the next week or two.
I
My lady,
appreciate that. Would that be sent to my email or?
Yes,
I
it
don't.
would. Yes, it will be sent to you by email.
Okay, because the reason why I said that, because I never received your Zoom or anything. So I'm
Well,
trying to figure out why I
checked
didn't
the
even
email
receive that.
myself during the, when we started and you were not present, I checked the correspondence that was sent out. And the email address corresponded with the email address that you stated to me in the directions hearing. So you provided to me directly on the 26th of May that your email address was, I don't have to read it out to you unless you want for me to, but d@moed.bm is the.
Okay, well, I'm sorry, I mustn't. I know it's
Check your
difficult
junk
as an
mail.
administrator.
Check your junk
I
mail and I would
checked,
suggest. Okay, well, anyway, if you are unsure, I would encourage you to contact the registry by the end of next week if you've not heard anything, and just double check to see whether or not you've missed any decision.
Okay, I appreciate it.
You do have to be contactable. What's the telephone number that you can be reached on? Can you email that to the Supreme Court at gov.bm instead of saying it on the?
I mean, if you don't mind taking it now,
I
is there a
don't mind
problem?
taking it now at all. What's the telephone number?
705
Mhm.
5070.
Okay.
And would it be a problem if I gave you my personal email?
I think you should give both emails. We want to contact you is the point. You're not getting an email from me directly. You're getting it from the court office. So however
what
it
I'm
reaches
saying.
you is, yes, what's the other email address?
Okay, it's SUPAD
Sorry, SU,
PAD
yes,
12 dot
12? Sorry, what came after SUPAD? 12? As in
12.
numerically or written out?
numerically, it's 12
Okay, thank you.
112 dot 1975
Mhm.
at gmail.com.
Okay. So it'll be sent to both email addresses. All right.
Okay, I appreciate that.
All right. So unless there's anything else I need to be addressed on, I will adjourn.
There's nothing else that I wanted to say in relation to Mr. Edwards, but I did just want to very briefly, because certainly from my part, there's no need for Mr. Edwards to remain. But I am conscious that we have another appeal tomorrow afternoon, my lady, and I'm just wondering whether it might be advisable to check that we're not going to have a similar situation tomorrow. It's a case in which the respondent, so it's a Crown appeal. The respondent,
This is Britain, is it?
yes, that's right. Yes,
Yes.
Mr. Britton. He was represented in the court below by Mr. Frumpkin,
Yes.
but Mr. Frumpkin has since communicated that he is no longer instructed by Mr. Britton.
Right.
But I noticed that the Zoom invite that was sent out by Miss Butterfield on the 4th of November was only sent to Mr. Frumpkin, and also I note to Mr. Swan. I'm not sure why Mr. Swan.
Okay. Can you just communicate by email what your concerns are with the registry staff?
Yes.
And then if they need some direction from me, they'll
Seek it.
liaise with me.
Yes. Okay. I'm just concerned. It rather seems as though it's likely the respondent is not going to appear, but we'll see.
Well, if that's the case, I'd like to know beforehand. I don't want to do any reading in just to find that it was time wasted. So
Indeed.
if you can just quickly, if you would prioritize that correspondence as quickly as possible.
I'll
that
do it
would
right
help me.
now.
And then I can give a direction as to whether or not the matter has to be delisted or relisted.
Okay. Thank you very much.
All right, thank you.
Bye.
Thank you. Matters adjourned. Thank you, Mr. Edwards.